Next on my list, and then Senator Whitehouse.
Thank you, Senator Feinstein. General Holder, thank you for being here this morning.
Morning.
I'd like to address three areas, and I'd like to start with the topic you were just discussing, the topic of drones. In your response to Senator Paul yesterday, you suggested there may well be circumstances in which it is permissible to use drones to target a U.S. citizen on U.S. soil. I'd like to explore those circumstances, and in particular you pointed to two. You pointed to Pearl Harbor and 9/11, both of which were extreme military attacks on the homeland. I want to ask a more specific question. If an individual is sitting extreme military attacks on the homeland, I want to ask a more specific question. If an individual is sitting quietly at a cafe in the United States, in your legal judgment, does the Constitution allow a U.S. citizen on U.S. soil to be killed by a drone?
For sitting in a cafe and having a cup of coffee?
If that individual is not posing an imminent and immediate threat of death or bodily harm, does the Constitution allow a drone to kill that individual?
On the basis of what you said, I don't think you can arrest that person.
The person is suspected to be a terrorist. You have abundant evidence he's a terrorist. He's involved in terrorist plots. But at the moment, he's not pointing a bazooka at the Pentagon. He is sitting in a cafe. Overseas, the United States government uses drones to take out individuals when they're walking down a pathway when they're sitting at a cafe. If a U.S. citizen on U.S. soil is not posing an immediate threat to life or bodily harm, does the Constitution allow a drone to kill that citizen?
I would not think that that would be an appropriate use of any kind of lethal force. We would deal with that in the way that we typically deal with a situation like that. You would expect
with respect, General Holder, my question wasn't about appropriateness or prosecutorial discretion. It was a simple legal question. Does the Constitution allow a U.S. citizen on U.S. soil who doesn't pose an imminent threat to be killed by the U.S. government?
I do not believe that. Again, you have to look at all of the facts, but on the facts that you have given me, and this is a hypothetical, I would not think that in that situation the use of a drone or lethal force would be appropriate, because the possibility...
General Holder, I have to tell you, I find it remarkable that in that hypothetical, which is deliberately very simple, you are unable to give a simple one-word, one-syllable answer, no. I think it is unequivocal that if the U.S. government were to use a drone to take the life of a U.S. citizen on U.S. soil and that individual did not pose an imminent threat, that would be a deprivation of life without due process.
Maybe I've not been clear. I said that the use of lethal force, and I'm saying drones, guns, or whatever else would not be appropriate in that circumstance.
You keep saying appropriate. My question isn't about propriety. My question is about whether something is constitutional or not. As Attorney General, you are the chief legal officer of the United States. Do you have a legal judgment on whether it would be constitutional to kill a U.S. citizen on U.S. soil in those circumstances?
A person who is not engaged, as you've described. Again, this is the problem with hypotheticals, but the way in which you have described this person sitting at the cafe, not doing anything imminently, the use of lethal force would not be appropriate, would not be something that could be ordered.
I find it remarkable that you still will not give an opinion on the constitutionality. Let me move on to the next topic, because we've gone round and round.
Let me be clear. Translate my appropriate to no. I thought I was saying no, all right? No.
Yeah, no.
Well, then I am glad. After much gymnastics, I am very glad to hear that it is the opinion of the Department of Justice that it would be unconstitutional to kill a U.S. citizen on U.S. soil if that individual did not pose an imminent threat. That statement has not been easily forthcoming. I wish you had given that statement in response to Senator Paul's letter asking you it. And I will point out that this week I will be introducing legislation in the Senate to make clear that the U.S. government cannot kill a U.S. citizen on U.S. soil absent an imminent threat. And I hope, based on that representation, that the department will support that legislation.
Well, that's totally consistent with the letter that I sent to Senator Paul. I talked about 9/11 and Pearl Harbor. Those are the instances where I said it might possibly be considered, but that other than that, we would use our normal law enforcement authorities. in order to resolve situations along those lines, and then use the normal things that you do when you try to decide if cops can shoot somebody.
General Holder, I'd like to move on to a second topic, which is what many perceive as the politicized enforcement of the law at the Department of Justice. In 2010, Congress heard evidence that the Department of Justice declined to enforce voter intimidation laws against members of the new Black Panther Party. In 2011, the Department of Justice released a statement announcing that the department would no longer defend the constitutionality of the Defense of Marriage Act, which passed with overwhelming bipartisan majorities both houses of Congress and was signed into law by President Bill Clinton. Last year, in 2012, the Department of Homeland Security announced that it would no longer enforce our nation's immigration laws against individuals designated by the President. My question to you is, are there any other laws passed by this Congress that the Department of Justice does not intend to enforce?
It is the tradition of the department to always enforce laws where there is a reasonable basis to argue for the enforcement of those laws. I have sent memos or letters to the Speaker of the House, I think that's where the letters go to, where we have declined to support laws, enforce laws that Congress has passed for a variety of reasons. I will note, however, with regard to DOMA, for instance, where we declined to defend that statute, that courts subsequently have agreed with us, applying that standard of heightened scrutiny, that in fact DOMA was unconstitutional. So it's not something that the Justice Department...
There was a bit of a sleight of hand there. You said courts have agreed on the merits on the issue. That is very different from saying there is no reasonable basis to defend the statute, which is what you suggested was the standard. Surely it's not the department's position that every case in which the department might lose a case, it will not defend the statute.
No, I'm saying that there was...
What process does the department engage in to determine which federal laws it will follow and which it will not?
Well, there's a presumption that we will apply and support any law that Congress passes. It is the rare instance where we make the determination that we will not. DOMA was one of those. We thought there was not a reasonable basis to defend the statute under applying that heightened scrutiny standard. And as I said, courts have, in fact, agreed with that determination.
Let me very, very briefly address one other area. Much attention has focused on the Fast and Furious program and the tragic consequences of that. Was the White House involved in any way whatsoever in decision-making concerning Fast and Furious?
No.
Given that, last year, my understanding is you asserted executive privilege against handing over documents concerning Fast and Furious. Now, executive privilege, the Supreme Court has made clear, protects communications and advice with the president. If the White House was not involved, executive privilege does not apply to those documents. If executive privilege applies to those documents, it necessarily implies that the White House and the president personally was involved. So which of the two is it, General Holder?
No, you're cutting too fine a line. The president, the White House was not involved in the operational component of Fast and Furious. There were certainly interactions, conversations between the Justice Department and the White House about the operation after all of the operative facts had occurred, after all of the controversial actions had been taken. When then we got into the situation where we were talking about the congressional investigation of Fast and Furious, there were communications between the White House and the Justice Department. But nothing...
Do I understand you correctly? My time has expired, so I want to just understand your response correctly. Is it your position that executive privilege only applies after the details of Fast and Furious became public, and it was with subsequent communications, but there is no executive privilege that is applicable before it becoming public because, as you just said a minute ago, the White House was not involved in any way, shape, or form with Fast and Furious?
Executive privilege protects communications between the White House and the executive branch agency, and to my knowledge, there are no communications that deal with the operational components of Fast and Furious between the White House and the Justice Department.
So executive privilege does not apply to them?
There's nothing there for executive privilege to apply to, as best I know.
Thank you, General Holder.